Lawyers Solicitors, what is the strangest or oddest law that's won a case for you? I won a case where the defendant, New York City, tried to exploit a really stupid law, which I was able to use to win the case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside of the Natural History Museum and shattered her arm and wrist. The law is that a property owner is responsible for the sidewalk directly outside of their property, the theory being even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very stupid law that they would be exempted from the rule that they can be sued for sidewalk injuries unless you can show they were on notice of hazard. Meaning, you would have to show that you informed the Secretary of State, Governor, Mayor, etc. of the exact specific crack in the sidewalk before the injury occurs, and you had to do so in writing with ample time for the city to remedy it, 180 days in advance IIRC. Under normal circumstances, this is impossible because no one anticipates tripping on the sidewalk 180 days in advance with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight, and there was a non-profit called Big Apple Maps which would go around the city and with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard, and then publish these maps while serving copies on the government, with the express purpose of combating sovereign immunity defenses in slip and fall cases against the government. I got hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" and gave them the map. Immediate settlement. Why is the sidewalk the responsibility of the adjacent property owner? Surely fixing the road is what taxes are for? In the UK, someone who isn't the government is more likely to be in legal trouble for fixing the street and interfering rather than doing nothing. Honestly, it's because the government is too lazy to do it themselves. The theory is that the property owner has the duty to monitor and warn guests, because they're always on the property and are in the best position to keep watch. They also have the duty to contact the city to have it fixed. The duty of fixing the sidewalk is separate from the duty to warn guests about it. Another example is snow. Owners have a duty to shovel snow on the sidewalk adjacent to their property. 47 U.S.C. 227b, Restrictions on Use of Automated Telephone Equipment. Law student working at law firm. We have a fax machine that gets tons of spam faxes. Our chief partner has a vendetta against spam, and he uses it to give us practice in researching and writing petitions. So we catalog each fax, send replies to take us off the list, document everything and wait for them to fax us again. Then we follow up with a FCC complaint and demand letter. A couple times this has ended up with the person getting mad and sending us retaliatory faxes, black sheets of paper. If they stop sending, we don't do anything, but we've gone into small claims a couple times, and gotten $500 per page a couple times. We also got someone trying to sell drugs through fax, but we just turned that over to the police. Imagine sending a spam fax about drugs to a law firm. I don't think I could hear of a more 80s scenario. The powder that comes out of the fax machine is not the right color. My brother is a lawyer. He got a DUI charge dropped for a client. Guy gets pulled over, cop asks him to step out to perform the sobriety test after he admits to having consumed some amount of alcohol. He complies, but after stepping out of his car asks the officer if it's okay for him to reposition his vehicle to move it further away from the road because he feels uncomfortable being that close. The cop obliges. Apparently the charge got dropped because the officer willingly let an intoxicated individual operate a motor vehicle. Fucking genius. I'm confused how that negates his initial crime. The officer obviously did not feel that the driver was too intoxicated to operate a motor vehicle, since they allowed him to. Typical INAL, but the first and only time I ever used the subway station's emergency door to get to the train, the ticket gate wasn't working. It was 3 a.m., I was a drunk college kid trying to catch the last train home. I got caught by 2 subway officers and given a ticket with a huge attempted fare avoidance fine. I showed up to the hearing in desperation, and they ended up having to drop the fine as they were reviewing the case with me because one cop had recorded that I entered through the right-hand emergency door and the other wrote that I entered through the left-hand emergency door. Never been so grateful in my life. I'm just picturing 2 angry NYPD officers yelling at each other in a comedic fashion. "Damn it, Tony, my left not your left." And so on. Oh, and of course one of the cops has to throw down his hat in anger. Had a family member get a DUI. He was sleeping in a parked car on the shoulder of a rural road across from a restaurant. Witnesses called in that he was drunk and had pulled over, stumbled out of his car, urinated on the roadway and then fell asleep in the car. When police arrived, the body camera shows him absolutely hammered stumbling. The officer asked him when he started drinking and he slurs out that he had started drinking at 9 a.m., it was about 5 p.m. He takes it to jury trial. His version of events in court was that he was driving sober, had pulled over, and then began drinking only once he was parked on the side of the road and therefore never actually operated the vehicle while intoxicated. Prosecution played the body camera of him hammered and stating he had been drinking since 9 a.m. The prosecution focused the jury's attention that the video statement and his in-court statements obvious both weren't true. His attorney stated that since he was so intoxicated in the body cam video that it was unreasonable to believe that he was telling the truth when he said in the video he had been drinking since 9 a.m. and that his in-court statement was more credible. He essentially argued that you couldn't convict him of being too drunk to drive based on the evidence against him because he was too drunk to make the evidence against him credible when he made the statement against himself. And they fucking ACQUITTED. Damn. Successful Chewbacca defense? Nah, it's a pretty rational defense. If you have 2 different statements by the same party that directly contradict each other, at least one of them should be disregarded as evidence. You would pick the most believable statement to accept as evidence. Whether you believe a blind drunk man stumbling around the bushes over the same man sober in a court of law under oath, but with a motive to lie, is up to interpretation, but both interpretations of which time he is lying have merit. My friend got off his DUI case for smoking weed with his buddy because the officer mixed up their last names. Sounds like all 3 of you were smoking weed.